Mr. Speaker.
I call the honourable member Kennedy Graham.
Thank you, Mr. Speaker. The Green Party concurs with the committee's report on the question of privileges concerning the defamation action Attorney-General and Gao v Lee. The House is invited to note our disagreement with the Supreme Court decision in that case. Our disagreement concerns particularly the Court's use of the test of necessity as a means for ascertaining the scope of Parliament's privilege of freedom of speech. In remediation, the committee invites the Government to introduce a parliamentary privilege bill into the House. Such a bill would clarify, for the avoidance of doubt, the nature of parliamentary privilege in New Zealand. This is an unprecedented move, I think, in New Zealand's constitutional history, and I am pleased that we have come to the place we are at. Allow me, Mr. Speaker, to make a few ancillary comments by way of support. This exercise, I suggest, has both a legal and a political dimension to it. On the legal merits, it might be queried, not least by members of our judiciary, by what authority would members of our legislature presume to judge the validity of a Supreme Court decision? It is a fair question. The answer, I think, lies not in any self-assumed level of knowledge and insight on the part of legislators. Few among us are qualified lawyers. I am not one. Among the few, there is, I think, not one complete authority in constitutional law. So it is not by any competitive notion of superiority in the trade that prompts the legislature and its Privileges Committee in the first instance to consider this constitutional move. It is in fact the obverse, the notion of cooperation between the two branches of government in finding the constitutional balance between them. It rests on an underlying notion that the political branch, that is the legislature, and the legal branch, that is the judiciary, must maintain a seamless, if differentiated, unity in the public interest. It is perhaps, with a touch of irony, the principle of comity that drives our response to the Supreme Court decision. The notion of mutual respect and restraint requires that, in the occasional event that one branch, always with the best of intent, encroaches, in the opinion of the other, marginally too far across that threshold of mutuality, then it is the right and responsibility of the other to restore the balance. That mutuality works both ways. In this case, it is the legislature responding to the judiciary. In another case, the judiciary is responding to the legislature when it makes its views known that a member's bill currently before the Justice Committee requiring a registry of pecuniary interest by judges is unnecessary, albeit well-intended, and could venture too far into the judicial realm, even though such a thing exists in certain other jurisdictions. Both responses from one branch to the other require mutual respect. That is the underlying basis of constitutional stability, the glue that holds society together on a civil basis. And so it is that the Privileges Committee has been careful to lay out its reasoning underpinning its view of the wrongful application of the doctrine of necessity in the case of Gao v Lee. It is careful to note that such a critique rests on advice of expert legal opinion. Some of the nation's top constitutional lawyers, members of the Law Commission, and the text on parliamentary practice in New Zealand that is perhaps the ultimate authority on the subject in this country. While the reasoning and the conclusions and recommendations in our report are, of course, our own responsibility, we are careful to ensure that they directly rest on and derive from such advice that we received. The issue is too important to do otherwise. And so, we cite the general principles of parliamentary privilege, freedom of speech and exclusive cognizance. We recall the basis for parliamentary privilege in New Zealand. We acknowledge the relationship between Parliament and the courts and the need to balance parliamentary privilege with common law rights. We considered the appropriateness of applying the doctrine of necessity to parliamentary privilege and whether, as a consequence, the same test would apply to other privileges. We convey our concern that the approach of the Supreme Court in this respect appears to narrow the protections of the Bill of Rights, Article 9. It confuses, we think, parliamentary privilege, which is an absolute privilege protected by Article 9, with qualified privilege. Much depends in this respect on the meaning of the phrase proceedings in Parliament. The court's decision, we feared, moves the interpretation of this phrase in New Zealand away from the interpretation followed in other comparable jurisdictions and could have a chilling effect on the ability of the House to receive information from advisers. Indeed, we go further, as David Parker has said, questioning whether it is even within the jurisdiction of the courts in this country to challenge the extent of parliamentary privilege in the manner done in Gow v. Lee. This, dare I say it, plumbs the depths of constitutional reflection as far, I think, as it is possible to go. In advancing the observation, members of the committee intend no disrespect, and we trust that members of the judiciary accept that assurance. So much for the legal dimension. There is also the political dimension of such a far-reaching foray into constitutional law. For in the final analysis, it is the people, the true source of all sovereignty, who must decide on the relationship between their various branches of government. To adapt an observation of the Law Commission in commenting on the pecuniary interest issue, neither the judiciary nor the legislature exists in isolation. They are institutions in a particular society. Their persons must have the respect and faith of the communities they serve to be effective. So the court of public opinion supersedes all others. And on that matter, I have only one observation to make. It is of paramount importance that the public understand the true meaning of the phrase parliamentary privilege, as the Honourable Chris Finlayson has noted. This does not mean undue or unearned material benefit for members of Parliament. It is almost the reverse. It means the protection of their freedom of speech, and in this case of officials advising them, for the sake of liberty and democracy. That is the inherent right of the people they represent. If this is clearly understood, there should be no problem expecting the people to understand why this Parliament has been so moved, why the Speaker felt compelled to refer the matter to the Privileges Committee the first parliamentary day after the Supreme Court's decision, why the committee has laboured so long and so carefully, and why its recommendations are so far-reaching. But if there is any doubt on the part of the public about this, we should do well to consider a change of phrase. We could use the phrase parliamentary protections rather than parliamentary privileges if it were to make the critical difference in the political context. I am aware of the weight of tradition that supports the current phrase, but there are two meanings to this word, and one seems to get lost in the static. Mr. Speaker, the Green Party concurs with the report of the Privileges Committee on Gow v. Lee and commends its recommendations to the House.
I call the Right Honourable Winston Peters.
Mr. Speaker, first of all, I want to recognise the